So, my name's Sarah, and I'm co-founder of Roots Up. And Roots Up is a new nonprofit focused on advocacy training and peer support. And we operate within an explicitly anti-force and anti-oppressive framework and work to raise up voice, choice, harm reduction, and the wisdom granted through our survival, as we like to put it. And this is actually Roots Up's second ever public event. And it's our second one focused on involuntary outpatient commitment because it's an issue that we are really prioritizing right now. And I want to give you a side note that I use this language of involuntary outpatient commitment, but you saw in our marketing assisted outpatient treatment. And certainly some people use that. We use that in the marketing because we wanted people to right away know what we were referring to, and that's the more familiar language. But at least within Roots Up, and I think within many psychiatric survivor communities, many people use involuntary outpatient commitment because assisted outpatient treatment is really kind of marketing language to make it sound helpful and supportive. And we don't necessarily want to be a part of that. So I think, and I think here you'll probably hear the language used interchangeably. I just wanted to say that. So I also want to note that we are recording this and we are going to be giving you a link to ask questions just because there were a lot of people registered just to make this more manageable. So I'll put that in the chat in just a moment so that you can ask your questions. You can put the questions in there at any time. And then when we get to the Q&A, we will start pulling questions out of there. And the
Oh shit, they froze.
Today, we're going to be hearing from Nev Jones, and Nev is an associate professor and clinical mental health services researcher in the School of Social Work at the University of Pittsburgh, and she's truly a content expert when it comes to involuntary outpatient commitment. And I do want to let you know before I turn it over to Nev that she has prepared a really thorough handout on IOC that I'll also be sending out tomorrow with that email, and that we're also already planning a part two of this event for people who want to go deeper into this. And I'll be sending that link out as well for people who want to register. And that will be in March, the second week of March. So with that, I'm going to put the link in the chat and turn it over to Nev.
Awesome. Thanks so much, Sarah. It's wonderful to be here. It's great to see so many people, quite a few of you I know, and lovely to see you here. Um, so the idea here, my team, and I'll pull up my little acknowledgement slide here. My team is doing a lot of active research on AOT now across the US, and then working on more legal and policy analysis under the Committable Collective. We recently completed co-leadership of the second legislatively mandated evaluation, also known as reauthorization study for Kendra's Law in New York State. We are not in a position to say anything. I am not in a position to say anything about those results yet, but stay tuned for webinars that will be scheduled in the summer after our report is publicly released. We are doing active AOT research, however, I will add both in New York and across the country, looking at variations in AOT legislation, how this plays out in terms of implementation, and people's experiences on the ground. And every now and then, or maybe more so in the Q&A, if certain questions come up, I might, kind of give examples or elucidate some of what we're talking about through that National Civil Commitment Project. Okay. If you are interested in direct access to all of the research, the individual studies, many, not all of which, but many of which are behind paywalls, please scan this QPR code. I just created a little form that you can fill out. Give me your email address, and I will be creating a shareable Dropbox or Google Drive folder that has all of the full text of all of the articles. And there's a couple of other questions there. Are you interested in getting future research publications, evaluation reports, related advocacy resources? So either now Pull this up on your phones, or you can wait until the end where I have bring it up again. All right. So some of the motivation behind this webinar, which as Sarah mentioned, I think we've kind of decided to really do the complexity of the material justice is going to require too. So we'll be doing a follow-up webinar that will go deeper into the research and also look at the international literature on involuntary outpatient commitment, which is largely excluded, except for a few reviews that are integrated here. So what are just, kind of some motivating thoughts? We frequently hear kind of sound bites about AO.
Nev, you got muted somehow. I'm sorry. I'm not sure what happened.
And that do not actually reflect actual scientific engagement with what we know and what we don't. One of the culprits, I think, is the 2025 ASPE evaluation, which I frequently hear being held up as quote unquote proof that AOT works, even though this is probably one of the most problematic evaluation reports I have personally ever seen published. And as we will discuss in subsequent slides, there are such serious problems that the U.S. General Accountability Office itself published a follow-up report in which the ASPE evaluation results are described as essentially meaningless. There are members of the general public who I think, with the best of intentions, want to see folks that they see struggling, really struggling, whether that is on the streets or whether they have talked to or seen interviews with family members, but who actually have no real understanding of what either AOT adjudication, that is the judicial process, or post-adjudication services actually look like. The reality of AOT, which I think is often very different from what the average member of the general public might have in mind. I think people often imagine that folks are getting swept up into person-centered, progressive services that work holistically to get them back on track, to assure community integration, that kind of thing. So there's really huge gaps to overcome in communicating what we actually do and don't know per the research literature, and communicating across diverse audiences who have ended up in one way or another kind of engaged in debates around assisted outpatient treatment / involuntary outpatient commitment. The very first section of this is just going to focus on sort of getting everybody on the same page in terms of what AOT is. This is brief. It's not an exhaustive kind of overview, but just to make sure we're all kind of thinking about the same thing. So AOT goes by many names, and historically, even in the United States, was more typically referred to as involuntary outpatient commitment, abbreviated IOC. But in recent years, AOT has become, I think, the most common term and acronym. Internationally, the two most common terms are probably compulsory treatment order, abbreviated CTO or CTOs plural, and mandatory outpatient treatment or mandated outpatient treatment, MOT. And just very briefly, what we're talking about is a court-ordered program of community mental health and or substance use treatment or services for individuals labeled with severe mental illness. That is part and parcel of the criteria for AOT, certainly across the US. I have in parentheses substance use because increasingly AOT is being expanded to fully apply to primary substance use disorders or diagnoses, at least in certain states, and there is even more legislation proposing that substance use or that AOT be extended to substance use. The legal framework, so AOT or IOC operates under civil law. Um, and a judge in some jurisdictions, this is not a judge, but a magistrate of the courts, mandates a specific treatment plan. Um, while the individual lives in the community, that does not mean that they cannot be and are not re-hospitalized while on an order. And the same logic goes for incarceration, whether that is jail time or incarceration in a prison setting. In most states, that would only kind of temporarily suspend the order, and then it would be picked back up when they are released from jail or incarceration in a prison. The mechanisms, the primary mechanisms as articulated in the literature is that IOC leverages the authority of the court. The court is, right, signing off on the order, and then enforcement, which tends to be outside of the court, although this varies by state. Sometimes there is a court liaison who serves a kind of enforcement role. But more often, it is the service providers who are then working with the individual who enforce through threats of involuntary removal, hospitalization, or medication over objection in order to motivate the individual to quote unquote adhere to treatment, and which may not get as much attention in more sort of mainstream materials, but to mandate accountability on the provider side. Sometimes IOC looks closer to a mental health court model, and sometimes they look very different. I think more often than not, they are really different. And some of that I will discuss when I get to the kind of the section on what we know and don't know in research terms about judicial process and due process. Eligibility in the US, this is an adult side intervention. Virtually every state has some version of serious mental illness criteria. Sometimes that's narrow or sometimes more expansive. As some of you are aware, for Care Court, which is sort of a version of AOT in California, originally it was exclusively tied to psychosis or a psychotic disorder. Um, the language in some form of likely to survive safely in the community without supervision is very, very widely used, and there is almost always clauses related to history of noncompliance and or recidivism, whether that is in criminal legal terms or hospitalization. Future risk varies a bit. So there are strict states, or what one could call strict states, where the evidence must be imminent danger to self or others. And this is closer to most states' inpatient commitment standards. And then there are states that have taken a more preventative approach, where the intervention, the involuntary commitment, is justified based on a need for treatment to prevent deterioration that would likely lead to harm to self or other, even if a crisis isn't happening in the moment. So this is more of a departure from an imminent standard. Some states also require that the individual be likely to benefit from AOT services. This is normally then deferred to the evaluating psychiatrist as to the likelihood that the individual in question will benefit. But in very, very rare cases, actually somebody their AOT order might be ended because an evaluating psychiatrist has indeed decided that they simply are not benefiting, that there is no benefit. And we have heard cases of that, certainly in the research that we've done. So it's not unheard of that this can kind of play out in a real way. The least restrictive alternative standards involved. So again, there is universal use invocation, usually explicit, in state statute, of least restrictive alternative language. And just quoting Judge Basil on here from the Lake v. Cameron decision, which kind of gives you a sense of some of the kind of legal precedent behind how least restrictive alternatives are understood. Quote, deprivations of liberty solely because of dangers to the ill persons themselves should not go beyond what is necessary for their protection. Interpretation absolutely varies by state, and I listed California here because this is not in any way to say California is perfect, but to say it is probably on the more progressive side, if one were at least to think about interpretation on a spectrum, in terms of what is required to prove that it is truly the least restrictive. So this first quote is just straight from California statute, and it holds that the person must have been offered an opportunity to participate in a treatment plan by the director of the local mental health department or the director's designee, provided the treatment plan includes all of the services described in Section 5348 and the person continues to fail to engage in treatment. In LA County, and as I understand it, this is by no means universal across the state of California, but Los Angeles, a very large county, requires a 30-day period of attempted outreach and engagement in voluntary services before AOT can be pursued. The one empirical investigation of this published to my awareness found that approximately half of people were then engaged voluntarily and not escalated into an AOT. And then actually for a variety of reasons, many other people also were not escalated into AOT. In other states, the sort of the least restrictive alternative standard is just assumed that basically AOT would be least restrictive than anything else. And we hear this frequently from judges and attorneys that we have interviewed. And usually their referent is either hospitalization or incarceration. And so they just have concluded that this person could only otherwise be hospitalized or incarcerated. There's no other possibility for them. And therefore, in comparison to institutional confinement in one form or another, AOT is least restrictive or less restrictive. This is just a kind of a graphic depicting the AOT journey. Now, because there is so much variation state by state, this is kind of an average, and I don't say that in a super scientific way. This is kind of an average across the probably 12 to 13 states where we've done deeper dive interviews and kind of can claim to really understand what's going on. And I will say that there are some really divergent jurisdictions in the US. In New Orleans, for example, it really is much, much closer to a mental health court model. And folks who are adjudicated under AOT check in with a judge every 2 weeks. That is wildly far from what we see in most other states. So again, this variation is very real. In this case, I used initiation in the hospital, and AOT can be initiated in almost every state from the community as well. This is probably more common, initiation in a hospital. So usually at this point, the individual is in distress. That's why they've been involuntarily hospitalized, and/or they are even more distressed because they have been involuntarily hospitalized. And often these are very, traumatic, or at the very least kind of unsettling and difficult experiences, meaning like what institutional kind of care looks like in these settings. A clinician, this could kind of really start anywhere, in terms of whether it's, kind of nurses, social workers, or psychiatrists flagging somebody initially. And then if the hospital or the county decides to proceed, sometimes the hospital will check with the county. Sometimes county council is even involved in reviewing the rationale if it's more unusual or maybe is more questionable or ambiguous, and then they file a petition with the court. So keeping in mind the kind of the state that individuals might be in when this is initiated during involuntary hospitalization, they often may not be in a position to understand what is happening or why. As many of you know who have either worked in or directly experienced inpatient environments in the US, communication alone can be extraordinarily complicated. So even being able to make an outgoing call to a public defender's office can be extraordinarily difficult, or to receive incoming calls. Again, the individual may still be experiencing acute distress, altered states when the process begins. For those of you who are familiar with mental health court models, where you have to restore competency if somebody is considered to be incompetent to proceed, right, with a trial or with a case resolution agreement under a mental health court, there is no such determination here. And in many states, not all. So there are states where it is not a possibility to waive the court hearing. The person has to be present, whether they are contesting it or not. But in many other states, including New York, it is very common for the individual, again, keeping in mind that they are often experiencing acute distress, desperately want to get out of the hospital to waive that hearing, in which case they may never meet the judge or have any experience of encountering a judge, which again is very, very different from a mental health court or any other kind of problem-solving court. The public defender is assigned. Often they can only engage in a brief phone call with the individual, not a meeting. Again, this varies depending on local kind of implementation standards, because ideally there is a true in-person meeting. And then very often the hearing is perfunctory, or again, as I mentioned, waived entirely under pressure. Judges have a lot of say in what happens locally as well. So I've heard even in states that allow hearings to be waived, certain judges will not allow it because they believe that due process is not served by a waived hearing. Defense counsel, so public defenders themselves may advise the individual to just agree in order to avoid a contested hearing, which could drag out their hospital stay. And again, just to emphasize this, the individual may not even grasp what rights they are waiving. Mandated treatment plans then. So again, state by state variation is that in some states, this is going to be very detailed and specific, including for medications, the exact medication, the exact dose, even in some cases. In other states, there's very little detail, and the court actually defers that to the treating team post adjudication. So that's quite variable. The individual is then discharged into the community. Again, order length varies, but typically an initial 90 to 180-day order, in most states renewable indefinitely. Post adjudication, again, lots of variation across states, but I am speaking here to some things that are pretty common. Providers must, and this is the term used in New York, is lay eyes on the individual, but physically see them regularly, depending on the state and jurisdiction. This could be weekly, biweekly, or less frequently. Very typically, long-acting injectables are used. There is actually research on that. A very high proportion of antipsychotics prescribed within outpatient commitment are LAIs. There are random or scheduled drug screens often included in plans, either in the court plan that is signed off on, or this is deferred to the discretion of the treating team. There's actually a lot of issues that I will just kind of flag here that we can't really dive into around abstinence versus harm reduction approaches to drug use and how that fits with involuntary outpatient commitment. There is typically some form of case manager who either directly reports to the court or indirectly via an intermediary structure that a given jurisdiction might have set up. Um, and in many cases, for people who are maybe their own representative payee for SSI, SSDI, that gets moved and or they are potentially being signed up enrolled in SSI SSDI for the first time, and so it is set up with a representative payee. And I note that because that means de facto that that individual has near total control over the individual's finances. May be more freedom there if it's a family representative payee, but I'm particularly thinking about group homes or supervised residential facilities of one kind or another. Now, they may have access to housing, be either prioritized or actually guaranteed housing, and this is something we'll come back to as a confound in understanding kind of the potentially causal relationship between AOT and any given outcome. But that's not necessarily the case at all. And in jurisdictions that don't have that capacity, plenty of people on IOC orders are and remain unhoused. There can be mandated program attendance, which could be IOPs, day programs, groups, can take a variety of different forms. Some places we've heard of individuals who have to show up at a particular facility every morning at a certain time for observed consumption of the medications they are prescribed. So maybe they're on an injectable too, but for the orals that they're on, they actually have to show up so that staff observe them swallowing the pills. And often very, very limited autonomy over daily choices, schedule, diet, or nutrition, and money, as mentioned. And then I'll actually just maybe go to the next slide because I think it's a little clearer to see here. I use the case of Allegheny County, Pennsylvania. So this is not New York, because often state administrators or policymakers will say there is no forced medication under assisted outpatient treatment or IOC. And technically, that is absolutely true. It is an escalation pathway that leads to medication over objection. So here, and we're only just rolling out AOT in our county, so some of this is to be determined in terms of what treatment plans really start to look like here in the county, but you have an AOT order issued. Then somebody, let's say they are adjudicated to AOT, what happens if they refuse medication? So the court cannot hold the person in contempt or otherwise sanction them for noncompliance with the treatment plan that is established by Pennsylvania statute. However, if the treatment team decides now they are deteriorating or relapsing, they can now argue that the person poses a danger to self or others, meeting the standard for an involuntary emergency examination, or 302 for those of you who might be from Pennsylvania. A Section 302 petition is then filed, or if police are involved, police can immediately transport without an initial petition having yet been filed. And the county, our county here in Pennsylvania has really tried to say that, well, this stuff just won't happen, but that is literally how AOT is enforced everywhere once it's implemented. And so law enforcement would then typically transport, take the person into physical custody, take them to an inpatient psychiatric facility, and they're on a hold. And then psychiatrists can consider medication over objection. And again, the medication over objection protocols and procedures are going to vary by state. In Pennsylvania, the facility may administer the medication over objection with a second opinion from a colleague of the treating psychiatrist without a hearing or independent panel, formal appeals process, or access to a patient advocate. In other states, some of these protections, additional protections or safeguards are in play. In practice, what we have heard from providers on the ground, and this is not from clients or individuals with direct personal experience do not even know this is happening. We have heard from hospital staff and psychiatrists directly that in many cases, a colleague psychiatrist of theirs in the community who is part of the treatment team or somebody from the county will have already reached out to them before the individual even arrives in the police vehicle, strongly suggesting medication over objection. And in some cases, the hospital or psychiatrist would already be preparing, meaning lining up their colleague before the individual even arrives so that they can swiftly pursue a medication over objection order. So again, that's how it happens. It is not directly under the IOC legislation, but it follows from the IOC legislation. Okay, now moving and definitely keep posting questions that you have into the interface that the form that Sarah set up. So kind of effectiveness and efficacy evidence. So there are three major randomized clinical trials that have been conducted on AOT. I'm going to AOT or internationally in the case of the UK, compulsory treatment orders. I'm going to go through each one. So the Duke study, this is Marvin Swartz and his team at Duke University, but this is not the Duke study, meaning the Duke evaluation of Kendra's Law in New York. This was an RCT in North Carolina that preceded it. In this case, the potential participants were all hospitalized and awaiting release with outpatient commitment orders. If they agreed to the study, they were offered essentially a 50-50% chance of leaving with immunity from an IOC for 1 year, for the duration of 1 year. There were 264 participants enrolled and randomized, and then there were, in fact, 67, quote, very violent clients who were non-randomized. And so all were moved into the IOC group. This introduces a lot of potential problems from a research design perspective. And one thing I will flag is that you have to work very, very hard across the different publications from this study to even determine which analyses are being run on the combined sample and which are really strictly being run on the 264 that were actually randomized. And then a further 112, which is no small amount, 20% were lost to follow-up by 12 months. So for the 12-month analyses, there were actually 219 participants, 47 of whom were non-randomized. Both groups had access to a case manager plus what is described as outpatient services. Really unclear. There was no public reporting, at least that I have been able to find, of what these services consisted of or how consistent they were across the two groups. Given all of that, there were no significant differences between the groups on primary outcomes. That is to say, no effective intervention and intent to treat analyses. And intent to treat is the gold standard, or I would say beyond gold standard. Most journals, respectable journals, will not even publish clinical trials without pre-published intent to treat analyses nowadays. And again, I just want to repeat this, no significant differences in hospital admission, length of stay, if hospitalized, violence, arrests, or treatment adherence. There was a significant effect on perceived coercion. In fact, IOC increased perceived coercion by 45%, and Black participants were twice as likely to experience high levels of coercion, even controlling for a number of factors. And the only other finding was a modest significant effect on reduced victimization, which there's sort of debate about how to interpret this. However, they carried out a series of post hoc analyses, and for those of you who are familiar with the term replication crisis in psychology, in the social sciences, the idea is that if you look for significance, if you slice and dice data after the fact of a clinical trial, you're almost certainly going to find at least something that is significant. Hence, to correct the huge problems of such practices in the past, it is now absolutely standard that you pre-publish, right? You pre-specify what your analyses are going to be, even subgroup analyses, and that the primary findings are the primary findings, period, right? So if your intent to treat analyses are null, they are null. And that is what evidence-based review standards hold the research literature to, including the Cochrane Collaborative. And so just to repeat, the Duke study in the Cochrane Collaborative reviews is treated as a null trial, and I'll come back to that. The Bellevue study, so this was at Bellevue Hospital in New York City. In this case, there were 567 patients, so from the hospital. So again, it is hospital release into IOC. 315 were eligible. 142 of those completed the baseline and were randomized. This trial just fully excluded individuals with, quote, history of violence for ethical and legal reasons. I think they could not obtain permission to randomize here. And Stedman, the Bellevue study, really went farther in assuring that the enhanced services were provided to both the court-ordered and control group. And that included a comprehensive discharge plan with patient participation, case management, and oversight by a dedicated coordinating team. So both sides got it. And again, there were no statistically significant differences on any major outcome, including rehospitalization, arrests, quality of life, symptomatology, treatment compliance, and perceived coercion. And just a note on the coercion front, although they did not differ, half of each group reported high coercion regarding medication and treatment. So something to keep in mind in interpreting coercion findings is that we often see what are referred to in the field as ceiling effects. Because measures of coercion can easily meet threshold even with voluntary services. So interpretation is complicated. And I do think it is worth underscoring that both groups improved significantly, right, on the clinical outcomes that were measured compared to pre-enrollment. They did not differ group to group. So the voluntary group and the involuntary group did not differ, but both groups improved. And I will come back to that issue, which we see kind of across the literature. And I'll come back to this sort of problem or confound of enhanced service access as driving these quote unquote improvements. So then the Oxford Community Treatment Trial, known as OCTET, gets abbreviated as OCTET, and there are actually many, many publications from the OCTET trial. The four I have listed here, just sort of particularly major ones, including 2013 was the primary report out after the trial completed. So the goal was, quote unquote, to conduct the most rigorous trial possible of compulsory treatment orders with prolonged high quality care. Again, controlled for on both sides, right? Provided to both sides. In this case, eligibility was limited to psychosis, so that is slightly different from the two US trials. And again, their primary outcome was readmission to hospital, and there was no reduction And their secondary outcomes were time to readmission, number of duration of hospital admissions, and then they measured a number of clinical and social outcomes. And again, there was no impact. So again, this was a null trial to repeat no differences between the involuntary outpatient commitment and control outcomes for any of those primary or secondary measures, nor for any of the pre-specified subgroups. So following best practices in clinical trial design and reporting, the Octet group pre-specified this, published them for the field, right, for scientific peers prior to conducting the trial. And that's the level of transparency that one ideally aims for in this work. They actually did follow-up research. So the 36-month follow-up, I'll just kind of read to you their own conclusion. We identified no evidence that increased compulsion leads to improved readmissions outcomes or to disengagement from services in patients with psychosis over a further 36 months. The findings from our 36-month follow-up support our original findings that CTOs do not provide patient benefits, and the continued high level of their use should be reviewed. And then their conclusion to that paper, the continuing spread of CTO legislation and their increased use despite no evidence of benefit in all 3 published trials is surely contrary to psychiatry's declared commitment to evidence-based practice. Further trials or modifications of the policy and practice are urgently needed. In 2020, they published a cost effectiveness paper. Now, I still included that, but of course, a big caveat is this is a UK wildly different healthcare system and healthcare financing behind it. But, quote, CTOs are unlikely to be cost effective. No evidence supports the hypothesis that CTOs decrease hospitalization costs or improve quality of life. Future decisions should consider impacts outside the healthcare sector, such as higher informal care costs and legal procedure burden. Cochrane review, and the most recent Cochrane review, I think they've done 4 or 5 total on the subject of involuntary outpatient commitment. The most recent was 2017. They did a systematic review and meta-analysis of the 3 RCTs. For those who are not familiar with the term meta-analysis, that means they actually got the data from the researchers, combined it and analyzed it together in order to obtain higher power, for instance, to potentially detect effects of a given intervention. Followed the rigorous Cochrane methodology and standards, which include significant peer review and oversight. Conclusion, no significant effect of IOC on any outcome except victimization, and that purely stemmed from the Duke trial, as we discussed earlier. They calculated a number needed to treat for benefit. That's abbreviated NNT most often, or NNTB in the Cochrane report. And that is that it would take 142 orders to prevent just 1 readmission to a hospital. And again, for those of you who have heard very kind of pro AOT advocacy that is not actually kind of grounded in research, this might come as a bit of a shock because that is an awful lot of utilization of involuntary intervention in order to prevent just a single readmission. Now, US non-experimental studies, this is a much larger literature, and it is really, really hard to deal with in a relatively short presentation. So I have a few highlights in these slides, but if you are interested in really kind of diving deeper, this is why we will be having a second webinar, and I will try to figure out from some strategy for kind of more systematically diving into the non-experimental literature. That means there is not a randomized control group, and you can't truly control for, therefore, the services and quality of services that people are getting in the groups. And there are kind of 2 general variations on non-experimental studies that we see. There are pre-post studies where the researchers are looking at what happened to people before the order and after, and there's no comparison to a different group. And then various matched control strategies where you match a control group of voluntary clients based on shared characteristics, maybe like from a large Medicaid data set. And there's more and less sophisticated ways to do that matching, but that's the general idea. So what are the caveats? What are the things to be very aware of when it comes to non-experimental studies? So virtually any study we ever see of any form of enhanced services, whether that is housing first, housing access, SSI, SSDI access alone, assertive community treatment, we could go on and on. We are going to see improvement in outcomes. So the fact that if you're looking at an AOT pre-post study and you see improvement, well, yes, that's exactly what we would expect from any kind of heightened service access, housing access, and access to supports addressing basic needs. Pre-post studies are structurally unable to disambiguate the benefits of these services of housing access from the involuntary court order itself, or what we could refer to as the legal coercion component. And in many states and jurisdictions, the intervention is assertive community treatment. So if you are comparing voluntary assertive community treatment to involuntary AOT, really the only difference, the only reason you would not be doing voluntary assertive community treatment is if you are making a case that the legal coercion itself is a necessary mechanism. A further confound that gets a bit less attention is provider accountability for the clients involved. But I really want to stress that because we all know that what happens in our very fragmented system is that providers and programs very often just drop people outright who are quote unquote too difficult. Pass the buck, so to speak, or pass the problem on to somebody else. Let somebody else deal with it. So it's a real failure of collective accountability and collective care for what happens to people, and just sort of dropping people from your client or program caseloads. That is not possible in the vast majority of cases under AOT IOC rules. And of course, when you are holding providers accountable, that also is almost certainly going to have some effect. And I will also just briefly mention indirect ways that this can play out is that residential facilities may feel very angry and frustrated when clients are quote unquote dumped at their facility, and then their case manager or ACT team abandons them, and something happens, and the individual needs support that the residential facility cannot provide, and they have no provider who will come and assist. So in many jurisdictions, we have heard then that the housing providers say we'll only accept someone if they're on AOT IOC, but it's not because they want the client to be involuntarily forced into treatment. It's because they want accountable providers. When we bundle all of those things together, it makes it especially difficult with non-experimental studies to kind of tease out what the mechanisms actually are. And then there's just a general principle of regression to the mean. In general, this means if you capture people experiencing more extreme things, doesn't have to be AOT, IOC, or a hospitalization. People who are really depressed are likely to regress to the mean and get relatively better, right? So that we find across all kinds of different outcome variables. But in this case, you would be thinking about people for whom this process is being initiated when they're often at their worst point. They're acutely distressed in a hospital, or potentially they're facing charges for something. And that's going to tend to improve after, over the longer term, even in the absence of any intervention. And quite literally, there have been studies that have looked at first episodes of psychosis, followed people naturalistically over time, found improvement across the board with no difference between those who had no treatment whatsoever and those who did. And if anybody wants me to dig up that reference, I'm happy to. Then I think the other kind of cluster of important studies is in New York State. And that includes the Duke evaluation or the Duke reauthorization study, the first reauthorization study for Kendra's law. And then there have been a kind of a series of other studies. Some of them I believe actually linked in a certain sense to the reevaluation study because that project, the funding for it was doubled by the MacArthur network. And so a lot of side projects and additional projects happened actually beyond the central evaluation that New York State covered the costs for. Um, so in the published pre-post comparisons, there was no control group. There were, unsurprisingly, reduced hospitalizations, increased psychotropic prescriptions or receipt of psychotropic prescriptions. Needless to say, this is actually intrinsic to the AOT order. So interpret that with, a grain of salt because we are risk conflating the intervention itself with an outcome of the intervention. And same is true of case management. If you are court ordered into case management, it would be absolutely shocking to not see rates of case management go up. The Fallon et al. Paper, this was again in New York City, used non-randomized match comparisons, so what gets referred to as a quasi-experimental approach. They found no difference in levels of psychosis symptoms or quality of life, although they did find reductions in suicide risk scores and violent behavior. With the latter, however, this was literally only based on 6 events across the entire sample. So again, should be interpreted very cautiously, 5 in the control group, 1 in the AOT condition. And there is very little detail, again, similar to the original Duke study, about what kind of services and supports they actually got and whether there were systematic differences for those who were in the AOT condition versus the matched sample. They did make something of an attempt to control for that, however, only looking at availability of a case manager, which is anybody who's worked in this space or experienced these services know that is only one component of any kind of more intensive service kind of plan or bundled set of services that you might be experiencing. But they did control for that. And again, this is, kind of not the ideal in transparency of reporting, but they quote unquote found that in some instances, the significant or marginally significant effect sizes became slightly stronger or slightly weaker, but we don't know which ones are which. And to the best of my knowledge, that is not publicly available. And even their conclusion was relatively modest. People's lives seem modestly improved by outpatient commitment. However, because outpatient commitment included treatment and other enhancements, these findings should be interpreted in terms of the overall impact, not of legal coercion per se. And so what they mean is if you're getting enhanced accountability, enhanced treatment, you can't know that legal coercion is the or even a active mechanism. And I just added this in this morning, even though I was going to kind of try to avoid too much of the international literature and save that for the next webinar. But because violence is literally the way that most AOT laws have been justified in the United States, motivated and justified. This is a very recent 2025 systematic review and meta-analysis of all available studies looking at the impacts of community treatment orders slash AOT, IOC on aggression or criminal behavior in people with a mental illness. That is the language that they used. And here are the results, just quoted straight from the paper. 13 papers from 11 studies met inclusion criteria. 9 papers came from the United States and 4 from Australia. 2 papers were RCTs. Results for all outcomes were non-significant, the effect size declining as study design improved from non-randomized data on self-reported criminal behavior through third-party criminal justice records, and finally to RCTs. Similarly, there was no significant finding in the subgroup analysis of serious criminal behavior. All right, ASPE evaluation. And I was worried that it was just going to be really hard to kind of fly through these slides as fast as I might need to. So we may not finish them, and I may end up skipping over some parts of this deck. And then returning to it in subsequent webinars. But I think it is really important to lay out the concerns with the ASPE evaluation because of the way that we are seeing it deployed in policy conversations. So this has been a very heavily critiqued evaluation with huge problems. Some of them had to do with factors outside of the research team's control, like the COVID pandemic hitting, which really disrupted a lot of data collection. So you see here that 3 original sites were replaced mid-study due to their basically inability to even collect the data. So this was mixed methods involving structured clinical interviews with AOT participants at 3 time points. This was supplemented with Medicaid claims data, arrest records, hospitalization records. There was also a family survey and cost questionnaire, which I just do not have time to talk about today. The comparison group. So this was the single site, which was in Alabama, and they did comparisons just at that site between the AOT programs at that site and a single voluntary act program at that site. So as we'll see, it was very statistically underpowered. These were the sites, just in case anyone is interested. And before going there, actually, let me just make the comment here that one of the big issues is that they had clinicians at the AOT programs conduct these interviews. So their pre-post findings were almost all positive. People's therapeutic relationships changed, their trust changed, their self-reported, quote unquote, criminal legal involvement and behavior change, all for the positive. But what you have to understand is that clients were literally being asked these questions face to face by the very people in position to make determinations about their release or discharge from AOT. There's almost no one, even non-researchers, who would probably hear that and not think that that is going to lead to such extraordinary bias that we probably don't even want to take that data seriously. But even if you say, no, we're going to just believe that they answered it honestly, there are serious problems. For the one comparison component, and this table comes straight from the ASPE report, there were actually only, by kind of traditional analyses, only 2 variables perceiving mental health as excellent. Yes, you're talking to the clinician and you're like, yes, my mental health is excellent. And then number of psychiatric IP nights, where there was clearly significant relative improvement, stronger in the AOT group versus the voluntary act group. Now, again, just to highlight challenges and problems of interpretation, Psychiatric inpatient nights is a very questionable category because when a hospital knows that somebody is on an AOT order, they're actually much more likely to discharge them more quickly. So the other thing I want to point out to you, as I was saying before, regression to the mean, people improve. On every single variable here, you see, yes, in a relative sense, folks on AOT improve or they score better, and the same thing is true for the voluntary act participants. Okay. And then the GAO report, again, because I don't want you to just take my word for it. And so I decided to just quote directly from the General Accountability Office's own report. And I do want to emphasize a couple of things here too. They obtained the actual data from the ASPE evaluation and could not replicate. And this footnote 9 in red is probably one of the most kind of damning things that you could ever have the GAO say about your evaluation report, but I'll just read it. We requested and received standard errors, which are a measure of the uncertainty associated with an estimate. We use standard errors provided by ASPE's contractor to calculate relative standard errors, which are calculated by dividing the standard error by the estimate itself. Relative standard errors for most measures indicate that estimates may be unreliable. And they chose to not even report back out the results of the evaluation because it was so problematic and so uncertain, given just the sort of the many, many, many methods, issues, and limitations. So just to quote them, we decided not to include the evaluation's result because we determined that ASPE and RTI lacked information needed to help understand the extent to which the results actually represented all AOT participants, and our analyses of information showed a high level of uncertainty for some of the results. So just to briefly summarize, 3 RCTs were null on primary intent to treat analysis, the gold standard of research in the field of mental health, found no effect of AOT on these primary clinical outcomes. Cochrane meta-analysis found a number needed to treat of 142 court orders to prevent just 1 readmission. The most recent global meta-analysis of available research, this is the Keisley et al. Paper, found no significant impacts on violence or offending. And the Duke study's arguably most robust finding was, in fact, a 45% increase in perceived coercion, with Black participants 2 times more likely to experience high coercion. The non-experimental studies, only a few of which we directly covered, are structurally unable to reliably separate effects of enhancement services and accountability from the court orders themselves. And the ASPE federal evaluation was flawed in many, many ways. So the bottom line is that no study has rigorously demonstrated that involuntary court orders add value beyond the enhanced services and system accountability that accompanies it. All right, judicial process and procedural justice. So I struggled with this because all best practices in kind of PowerPoint design would tell you that you should not put big text dense quotes up on a screen for people to read. And I felt that paraphrasing could so water down the findings that I couldn't persuade myself to do that either. Because of time, I think I will read just a couple of these, and then everybody will be getting a copy of the slides and can read them at their leisure. So this was a publication in 2015 by a legal scholar, JD PhD, Candace Plyer, on Kendra's Law in New York City. So these were judges and attorneys. For those of you who are from New York, that would be mental hygiene legal services attorneys. And this is just reading from the section on judges' views on expert testimony. Quote, many judges reported that they rely on clinical recommendations, particularly when the clinician has appeared before them in prior hearings. This is a field, quote, this is a field, and I'd like to think all the other judges have said this too or admitted this, that quite honestly, it's heavily weighted in favor of medical testimony. To that end, expert witnesses generally perform two functions during AOT hearings. The first is simply to educate the court on unfamiliar diagnoses and medications. The second, to provide a clinical recommendation regarding the necessity of AOT. In doing so, judges are particularly attuned to how doctors answer questions on cross-examination. As one judge commented, I rely heavily on what the doctor says, meaning everything the doctor says. So if this is a contested AOT, obviously that includes the doctor's responses to cross-examination questions. Some judges explain that while they are willing to modify AOT orders based on the legitimate concerns of AOT patients, they are reluctant to deny an AOT petition outright unless an expert testifies on his or her behalf, as one judge put it. I am not a mental health professional, so if a mental health professional testifies that this is what is needed, I have no basis to say no. When I actually get a presentation from the other side, I take it seriously, but I need a basis. And I won't read all of this, but it's extraordinarily difficult. Usually there is no funding for public defenders to employ experts to testify with maybe a critical view of the order or its contents. So that overwhelmingly simply does not happen and is not an option. On evidentiary standards, so this is, again, striking. The standard of proof, just as a reminder, for an assisted outpatient order is clear and convincing evidence. Although New York courts have defined clear and convincing evidence as evidence which makes the existence of a fact highly probable, only a few judges define the standard of proof in similar terms. Most defined clear and convincing evidence broadly as more than a preponderance of the evidence, but less than proof beyond a reasonable doubt. Others suggested that in practice, the important question in AOT cases is whether the respondent would benefit. Quote, it's mostly evidence that shows this person has a problem and would benefit from AOT. Quote, I listen to what they have to say and I go with what makes the most sense. Quote, I do what I think is right. Quote, judges will do what they feel is the right thing. Now, these are non-clinicians who typically have no experience outside of a courtroom working with folks experiencing what gets labeled SMI. Attorney views, judicial attitudes towards people with diagnosed or labeled with mental illness. Several attorneys indicated that judicial attitudes towards people with mental illnesses and the AOT program make it difficult to win cases. As one attorney said, judges tend to think that people with SMI, I'll just say, are all crazy and nuts because every once in a while some guy goes on a rampage and does something terrible. Nor do judges see much downside in granting AOTs. They figure, what is the harm? The person is going to be provided with services. It's protecting the community should anything happen. A handful of attorneys in both judicial departments. So for those of you from New York, this is 1 and 2 from memory, also reported that judges do not credit their client's testimony. Attorney, one of the other major problems with AOT is that the client's testimony means nothing. It's not given any credit or any weight. Interviewer, how can you tell that the judge is not taking that into account? Attorney, because they'll say things off the record about it, which you don't see in the transcripts. And I will just read this and then move on because I know we are short on time. So this is now the attorney perspective on expert testimony, right, and judges' deference to clinicians. Many attorneys noted that AOT hearings are particularly difficult to win without expert testimony. Part of the problem stems from the criteria for issuing an AOT order. So again, this is specific to New York, but Section 9.605 of Kendra's law requires clear and convincing evidence that as a result of his or her mental illness, the respondent is unlikely to participate in outpatient treatment voluntarily. And Section 9.601 requires evidence that the respondent is, quote, unlikely to survive safely in the community. As one attorney remarked, that's pure opinion. There's no fact. Judge X is always going to side with the doctor, and that's part of the problem. And they go on to explain how the only way to win is on a technicality, because substantively, if you have judges who automatically defer to a single evaluating psychiatrist, you simply cannot win. Okay, and I'm not going to go through all of these, but please read them. There are some highlights. Again, people who sign up to get the access to the full articles in question can read the entire publication, which has way more detail even than my slides here. And then very quickly, I want to talk about a comparison or potential comparisons between AOT versus mental health courts. And just as a reminder, I think those of us who maybe grew up watching legal shows on TV and have in our heads this deep belief that there is always an adversarial process, right? That you have the kind of the defending and opposing counsel really going at it and cross-examining people, and there's all this substance to the court hearings. A lot of that is wholesale absent on the civil side and particularly absent maybe from AOT proceedings. In contrast, mental health courts, which are on the criminal legal side, preserve much more of that formal competency assessment. As we discussed, you have to be competent to proceed with agreement, and that could be a long time, that could be months or more, before you then work with, depending on how it's set up, maybe starting with the public defender's office, but start to develop a plan that becomes the case resolution agreement that will resolve the criminal charges that you face by going through the diversion court process. This very strongly protects against people making decisions like waiving their right to a hearing while they are experiencing acute distress or altered states or trauma because they're in the hospital. Entry into the court is voluntary, and it is strongly based on principles of therapeutic jurisprudence, which heavily stresses a relationship with a caring judge as central and baked into court design, that there is a real relationship there. And again, very, very different from what we see on the AOT side, where in many states, literally the person has never so much as exchanged a single word with the judge. So the only published study, to my knowledge, that has directly compared experiences of mental health court to AOT is this 2014 paper from Ohio. This is Mark Munitz, who's retired now, but was at Neomed. So they looked at the experiences of 35 misdemeanor mental health court participants compared to 17 AOT participants. And actually, the authors themselves underscored that because it's a misdemeanor court, if anything, the participants would be probably less likely to describe it in super favorable terms because what they're avoiding is much less than if it were a felony diversion court and they were actually avoiding years of prison time. So in comparison to the mental health court participants, the AOT recipients reported significantly higher perceived coercion, every dimension measured, decisional agency, choice, control, freedom, significantly lower procedural justice in interactions with the judge, every dimension measured, and then significantly afforded that they felt that they experienced less respect, and the wording of the item doesn't, there's no referent in terms of less respect from who, just less respect in general, after completion of AOT than prior, and that they were significantly less hopeful after completion of AOT than prior compared to mental health court participants. So quick summary, judges overwhelmingly defer to the single evaluating psychiatrist. Psychiatric evaluations are often very brief, conducted by clinicians with no treatment relationship, and maybe structured as fact-finding hunts to meet statutory criteria. There's a very powerful quote and section in the Plyer paper about that I just skipped over. And again, the contrast with mental health courts. Okay, very, very briefly now, I'm going to go through the harms. I will just say that my team is working on a series of publications documenting these harms, but I am here more presenting them as, I guess, known areas for which we actually currently lack any publications in the US. So, except I guess with the exception of coercion. So coercion itself, and I think I've kind of covered this well enough, but I will add that when you measure coercion with close-ended items. One problem is ceiling effects, that if you've been in the system long enough, you've already maxed out your coercion threshold. You can't go any higher. AOT doesn't go any higher than what you're otherwise experiencing or would experience in many quote unquote outpatient and certainly inpatient environments. The other thing that is a problem with closed-ended quantitative items is that people who have experienced so much, which I'll go on to describe in a couple slides, social defeat, may not report in a close-ended format what they're really experiencing. You may only learn that by really talking to them about their experiences, getting them telling stories about what is actually happening to them. And Phil Llanos and his team in New York have published the only paper to my knowledge that not only examines this difference between quantitative report and in-depth interviewing, but specifically in the context of coercion in AOT, and found significant differences. People underreporting negative experiences quantitatively and then opening up with stories about precisely that when asked. And this was involved a comparison group of voluntary ACT. Other sources of potential harm, I'll go through this quickly. Medication side effects. If you don't already know this, polypharmacy is extremely widespread in AOT, including regimens as much as 3+ antipsychotics, plus lithium, plus maybe an anxiolytic or antidepressant, plus multiple medications to address psychotropic side effects, including those with high anticholinergic burden. And this can lead to any number of serious side effects: kidney or liver toxicity, cognitive decline, and dementia secondary to anticholinergic effects, extreme lethargia and cognitive slowing, metabolic syndrome, various, kind of heart conditions, and type 2 diabetes. These are not light side effects, right? Medication effects are often compounded by poverty and poverty-related de facto segregation. If you're familiar with literature on food deserts and where most people on SSI are sent, or where group homes and residential facilities are located, right? If they're in group homes, they don't even have control over what they eat, no access to exercise facilities, no access to green space, on and on. So you have kind of a perfect storm of both direct medication effects and environmental conditions that easily lead to very, very serious health conditions. Research that has actually focused on this in the context of AOT in the US, zero to our knowledge. What I am calling custodial iatrogenesis. So this is institutionalization in the community, and would share the most in common with studies, which actually many of which were conducted during the height of the state hospital era, on institutionalization in state hospital settings. And it's really just seen the same thing, but in community settings. So it's total control over the person's life. The facility functions as their rep payee, controls all their money, their food, their transportation, their social life, who they can live with, who they can see, who they can't in many cases. This creates dependency, internalized powerlessness, and lack of agency, and all too often resignation to a life without meaningful social involvement or community inclusion, and poverty. Just, straight out ongoing poverty with no real escape from it. Research focused on this in the context of AOT in the US, zero to our knowledge. And again, we are working on it. Disruption of family bonds and ties and reproductive injustice, very quickly. We have interviewed a number of people with very serious concerns about the impacts of the complex, multiple, medication regimens they're on with respect to a developing fetus, as well as indirect effects through cardiometabolic and glycemic dysregulation pathways. So, as many of you probably know, development of diabetic conditions is common even in a regular pregnancy, or relatively common and compounded here, and that has a cascade of effects on the pregnancy. Loss or fear of loss of custody and rights over minor children or older adults for whom the AOT recipient is a caregiver. We heard about this both from have heard about this both from people subject to AOT orders as well as from caregivers. And in other cases, AOT orders can also be exploited. So we have run into at least a couple of cases of ex-partners obtaining custody of children, and pretty kind of punitive conditions attached with that, by basically bringing to the courts, well, their other parent is on AOT, clearly an unfit parent. They should not be allowed to see their children, that kind of thing. So again, direct and indirect impacts, and then physical separation if a particular supervised residential placement is part of an order. Let's say a parent can be moved to a facility far away from their minor children, and let's say this is a high poverty family, they don't have a car. As we see with incarceration, it may be impossible to visit, and we are severely disrupting family bonds. Again, zero research specifically in this on the US, other than to my knowledge what we are working on. And then social defeat. And I won't go into detail here, but a general definition is the chronic experience of being excluded, subordinated, or rendered powerless by one's social environment. And I have to say, in doing interviews with people directly on AOT orders, one of the saddest things is hearing people say, this is just the way things are. Nothing can or will ever change. And when we ask, what are your suggestions for policy change? They say, I don't even have any. It's just the way it is. It'll never change. Right. And that's a real reflection of social defeat. That is exactly what social defeat is trying to kind of get at. But again, can involve this loss of autonomy over one's own body that we see, loss of control over potentially almost every aspect of daily life, and kind of chronic subordination to institutional authority, right? You're just told what to do. Repeated experiences of having one's voice disregarded. And again, we saw both judges and attorneys attesting to that in the court process. So not even coming from the clients or the families, but straight from the judges and attorneys. Social and structural racism seriously compounding that. And there is so much to say about structural racism in the AOT space that, again, was planning to save that for the next webinar. This non-compliance framework, anytime you try to assert autonomy, for instance, by refusing a medication, that becomes framed as evidence of illness or defiance. And we hear this a lot, especially from men, especially from Black men, right? That the way it is responded to is as if they are being aggressively defiant when they are trying to assert their agency through some form of refusal. And there's no defined endpoint. And you could say, unlike incarceration, although this is not always true, depends on the terms of incarceration, but AOT orders in general can be renewed indefinitely. And often people have both no idea why they ended up on an order they're on, and they have no idea how they would get off. Okay. Overall summary, and then we are almost out of time. So maybe I will just leave this up and open it up for questions. I am happy to stay afterward. So if you have a lot of questions and don't have to leave at past, I will stay here. But otherwise, just thank you. Thank you for being here. Maybe I will just quickly put up the QPR code. So if you do have to leave and haven't yet filled it out and want to, just take a picture now, and then I'll just go back to the summary.
Thank you, Nev, so much. And I wish we had more time. And for those of you who are going to come back to the next one, we will leave a little more time. We already talked about, oh, let's make the second one a little longer so we can be sure to have more time for Q&A. There are a lot of questions, and I think even if you stay late, we're not going to get to all of them right now, but maybe we can also take a look at including some answers in the email that I send out, particularly for the ones that have clear answers. But I did make a note of a bunch of them, Nev, and one I think that might be pretty quick for you to answer is somebody asked if the GAO report, is it normal for them to replicate studies in the way that they did, or did they do that specifically because there were already so many doubts or concerns about the validity of the ASPE study?
I mean, I can't claim to be an expert on the GAO. Everybody I have talked to about this particular GAO report has found it quite extraordinary. And keep in mind, too, that it was released under the current administration, an administration that has generally been very publicly pro AOT. So there has been a lot of speculation, but no one I know has any kind of insider knowledge. But I would not call it typical.
Okay, thank you. All right, so another question. In New York State, at the onset of an IOC court order, 7% of people are inpatient and 1% are incarcerated. At the expiration of an IOC court order, 9% are inpatient and 3% are incarcerated. Have you seen any research that might help explain why a person on an court order would be more likely to be inpatient or incarcerated at the time of the end of the order?
So some of it in certain states, and this is definitely true of New York. So in some states, the order might be considered to be continuous to span the time that a person is incarcerated, or especially in a state hospital. In New York, it ends or is paused and then restarts or is renewed when they're released. So therefore, you're gonna tend to see disproportionately where you're looking at an endpoint tied to discharge from the order or to the order ending, you're gonna see that, I think, elevated rate of typically, I am guessing, actually state hospitalization and or incarceration.
So the next question was one that was a little bit more personal, Nev, in that the person who wrote it said, you know, I basically that they have their own struggles and they want to be involved in this advocacy, but it takes a real toll. How do you take care of yourself and stay in this work where there's so much injustice that you're facing all the time?
Um, I think it is a sense of responsibility to a lot of the folks that we have talked to, and I would very much include family members and probably a lot of folks in the room are familiar with pro AOT family advocacy, and when one is actually focused on interviewing people with direct experience, their loved one has been directly impacted. Some of the very most gut-wrenching stories we have heard have come straight from family members. And there is a real sense of responsibility, and a lot of people feel like no one is documenting what is happening. Nobody is speaking out about what is happening, and therefore nothing is going to change. And so while it is really, really heartbreaking, a lot of what we run into, I think what is very motivating about this work is how important it is to people who are impacted and how silenced or disempowered they often are or currently are, and know no remedy.
Thanks, Nev. And I want to recognize it is 1:30, which was the official end. So thank you to anyone who has to leave, but will stay on for a bit longer. Okay. So another question was around if it's not working and people are seeing that it's not working, how often are you seeing providers end an IOC order because they admit that it's not helpful? And do you have a sense of a percentage of how many IOC orders get ended for that reason? And if it ends for that reason, is there an alternative plan that is made as a part of that process?
I mean, it's something anecdotally we have maybe only heard a handful of times. It's maybe something that we should be more systematically asking. I think just self-reflecting on it. There's a lot to get through when you're interviewing providers. So maybe we need to just more systematically ask about that. It's not a reason for discharge in every state, so it doesn't always apply, in the context of the national work that we're doing. I would say again, the second, maybe most heartbreaking thing, the first most heartbreaking thing, right, is the stories of people directly impacted, individuals or family. The other thing that is in its own way, very, very hard to hear is the providers who say we have no other option, and you hear that all the time. There's simply nothing else. We don't know what to do to support people. It's AOT or it's the hospital. Often by which they mean state hospital, right? Like long-term institutionalization. And there's nothing else. And when we ask, can you imagine something else? Can you imagine something else? No, no. People turn up total blanks. And a few people in the audience, I think, know that I was part of a study trip to Trieste, Italy last year, which I actually had very low expectations of. Oh, this is yet another overhyped, outside the US, grass is greener kind of thing, but who would turn down a free trip to Italy. I was so profoundly moved what I saw there. It is so real what is they have accomplished. It is so profoundly different from systems of care and support here in the United States. So, is it possible to do things very, very differently? Absolutely, it is. All you need to do is, travel to Trieste to see that in real life brought to fruition. But the fact that providers here can no longer even imagine that, can't fathom it, is incredibly sad, right? It's incredibly sad and it's incredibly worrisome because if we can't even imagine things being different, we really have resigned ourselves to the status quo in a pretty profound and powerful way.
And this is my own interjection, but in my experience, when we keep the options like IOC and like other measures of force so present, I have found that that's what kills the imagination. We're just like people think, oh, well, that's the option that we have to do. Has that also been your observation?
Yeah, absolutely. That coercion becomes a default, and the more it becomes a default, the more it becomes a default. And it's not just the actual sort of the act of coercion, or acts that involve coercion, but it's the entire logic, the thinking that goes along with it, the rationalization, which comes to seem second nature or even beyond second nature. People are no longer conscious of the extent to which they are just defaulting to coercion. And I actually contemplated putting this up, but George Schmuckler and Paul Applebaum is a past president of the APA, actually wrote a rather remarkable paper in which they lay out all the sort of normative forms of pressure and coercion in mental health, just as an absolutely everyday thing. But they are trying to, draw distinctions between the most kind of everyday threatening, cajoling, incentivizing, all the way up to more extreme physical forms of coercion. So the more that is the sort of the set of principles and practices that in an invisible and unaware way serves as the foundation for our system, it's no wonder we have ended up where we are. It is daunting to think about what it would take to change that because it is pretty profound cultural change. I mean, the deep culture of public sector mental health services in this country. And then I think often if you look between, let's say, state hospitals as maybe the most extreme cases and outpatient, you see an even deeper, right? Even deeper kind of dehumanization and objectification that gets profoundly normalized in those settings.
So the next question was about racial disparities. The racial disparities in the research in New York are pretty clear. They have been for a long time. But the question is really, is there data to support that there are racial disparities in the implementation of IOC in other states and what groups are found to experience those disparities in other states that you've seen?
I mean, in the qualitative work we're doing, absolutely, but that is hearing people's kind of on the ground experiences of facing racism, racial discrimination. When it comes to data, this is a whole nother kind of complicated question because there's very few states where one can publicly access data in this way. You could say that states like New York and California are more progressive because there is some degree of public reporting and transparency in most cases. In most states, that's not true at all. And the same thing is rather notoriously true on the inpatient commitment side, because we do have that for more states on the inpatient side. I can say that yes, we see this over and over, especially for Black individuals compared to white. Um, and technically this gets referred to as a disproportionality, and then documenting the sort of the mechanism of racism would take us intentionally doing that, which, just to kind of get back to the harm slide, has been a huge problem, is that there has been a huge failure collectively in the United States to care enough about these issues to develop, pursue, or, be able to obtain funding for the kind of studies that would really document racism as mechanism, not just the disproportionality, although you can say it's so over the top in some cases, including things like even once you are in AOT, the disproportionality around police involvement, right? So people being subject to removal orders, pickups, they go by names in different states. So we know that that's incredibly disproportional, and so much so that, how can you not call that racism? But that's all we have are those percentages, and we need really a ton of documentation of what's really going on and how it's impacting people. And we have every reason to believe, and certainly, what kind of qualitative research yields is the deepest of deep concerns, about really every facet of this, especially when it comes to, I think, kind of Black men who have been labeled with schizophrenia, where there is such a deep history of racism in this country, and the conceptualization of the schizophrenia construct, as Jonathan Metzl, for those who are familiar with his work, has historically documented, in the very labeling with schizophrenia, in the prescribing of medications, and on and on. So we just need the work to document it so that somebody can't say, well, that's just anecdote or speculation.
Thank you. So the next question was about whether or not being on an involuntary outpatient commitment order could show up on someone's record. And the person who wrote that question was particularly concerned if there was like a criminal record check, could it show up for housing or employment? But I also want to add on to that because we right now in Massachusetts have a law proposed for people, for the police and others to be able to access a database of people who've been committed. Have you seen how involuntary commitment shows up in states where those laws exist, where that sort of communication happens, uh, and how that can impact?
I mean, it generates huge fear, on the part of individuals subject to AOT orders. We have recently heard that very much compounded for people who are undocumented, um, obviously because of ICE, and people have lost licenses, certainly. So, depending on the licensure, we've heard this for lawyers, for sure. And there are, then, just a host of variations by state. So I think it's another topic that if one could find a way, to really look into the impact. It would be incredibly valuable with large-scale data access or something that doesn't exist to my knowledge. But um, depending on the state, this could play out through a variety of mechanisms, including so-called kind of gun flag laws and policies. Right. So it's very likely that in most states this gets reported to um, law enforcement at a minimum, if not other kinds of entities. And then people may be asked to report it, which is very common for every type of licensure that I'm aware of, where there are questions asking people to report any civil commitment. So then you're in the position of, well, do I lie? So it's not necessarily that it has been reported to them, but the individual has to grapple with the implications of how they respond to those kinds of questions. So I think it's very serious, and this is often part of the rationale for various forms of diversion. So in California and LA, um, this is something that will be held out to people as if you voluntarily agree to XYZ, you will avoid the court record, which could have all kinds of implications. And then, as I mentioned earlier, the same thing is certainly true for custody, for DVIPV. Once this is somebody's part of somebody's record, so to speak, it becomes very powerful in terms of how it can play out in other areas of their life or wholly separate, kind of legal issues and legal entanglements like custody.
Right. So maybe one more question because we're already almost 15 minutes past, but one question was about the public defenders that get assigned. Do they necessarily have appropriate treatments to support the people they're representing? Have they had some sort of mental health treatment or to understand the issues at hand, or even to understand the efficacy or lack thereof of involuntary outpatient commitment?
Hugely variable, and not even like just varies by state, varies hugely within a state. This is something we always ask attorneys when we meet with them. Sometimes there are basic trainings offered, sometimes just absolutely nothing, literally nothing. So they really have no background unless they have sought it out themselves. I do want to say we see incredible variability, having now kind of interviewed quite a number of attorneys in different states. There are some absolutely incredible humans who do everything in their power to support the clients that they are assigned to and on their own time to learn in the deepest possible way about the issues. And then there are people who are just kind of completely flip about it. This is basically just a waste of my time. They just need to sign on the dotted line. Um, so it's very, very variable how this plays out. Strong leadership in a given jurisdiction, like in a public defender's or in New York, an MHLS office, can of course make a huge, huge difference, right? If the leadership of the unit is really invested, that's going to make a huge difference.